They called him the ghost of the valley. For 42 years, Arthur Vance lived on a patch of jagged, uncultivable earth that the rest of the county treated as a landfill. The locals laughed when he refused buyout offers from real estate developers, laughing even harder when the county tax assessor tried to seize the land for pennies. They thought he was an eccentric old fool clinging to worthless dirt. But Arthur wasn't foolish, he was patient. And on a rainy Tuesday morning in the county circuit court, the laughter stopped. The bailiff carried in a rusted steel lockbox, sealed with heavy wax and stamped with a date, November 14, 1978. When the seal was broken, a half-century of town secrets began to unravel. To understand why the town of Oakhaven mocked Arthur Vance, you have to understand the geography of greed. In the late 1980s, Oakhaven transitioned from a sleepy agricultural hub into a booming suburban enclave. Prime farmland was swallowed up by master-planned communities, strip malls, and golf courses. Land prices skyrocketed from $800 an acre to nearly $50,000. Yet, right in the center of this booming development sat the Vance parcel, 80 acres of rocky, uneven terrain that sat in a low-lying flood basin. It was visually ugly, geographically problematic, and seemingly useless. The townspeople, led by a prominent local developer named Harrison Vance, Arthur's estranged second cousin, treated Arthur like an eyesore. Harrison had successfully corporate-zoned every square inch surrounding Arthur's property. He built luxury townhomes right up to Arthur's fence line. To the wealthy suburbanites moving into those townhomes, Arthur's rusted tractors, overgrown weeds, and modest timber cabin were a blight on their property values. The mocking wasn't just passive whispers at the local diner, it was an organized campaign. The town council, heavily influenced by Harrison's development firm, hit Arthur with code violations almost monthly. They fined him for unharvested brush. They fined him for operating an unlicensed agricultural storage facility, because he kept his grandfather's 1950s tools in an open barn. Every week, a new deputy would pull up his dirt driveway to deliver another administrative citation. Through it all, Arthur never yelled, never protested, and always paid the fines in cash at the county clerk's office. He was a quiet man, dressed invariably in faded denim and a worn canvas jacket, his face lined with the deep crevices of a life spent entirely outdoors. When the town clerk sneered at him across the counter, asking why he didn't just sell out to his cousin Harrison and retire to Florida, Arthur would simply offer a polite, tightly wound smile, pocket his receipt, and walk back to his truck. The general consensus in Oakhaven was that Arthur was mentally unstable. Why else would someone endure decades of harassment, pay thousands in arbitrary fines, and live in relative poverty when Harrison's firm had openly offered him $2 million for the basin? The town assumed Arthur simply didn't understand finance. They thought he was a stubborn relic of the past, standing in the way of inevitable progress. But what the town council and Harrison Vance failed to realize was that Arthur Vance possessed something far more dangerous than money. He possessed an impeccable memory and a profound understanding of foundational property law. Arthur knew that in 1978, long before the suburban boom, long before the town council was bought and paid for, Oakhaven was a different place. It was a place governed by handshake agreements, strictly recorded deeds, and old-school legal maneuvers designed to protect family lineages from corporate overreach. The breaking point arrived when the town council attempted their ultimate gamble. Invoking a highly controversial municipal ordinance regarding urban blight and public safety drainage risks. The council voted to condemn Arthur's Basin under eminent domain. They claimed the valley needed to be converted into a municipal storm retention pond for the safety of the surrounding subdivisions. The compensation offered to Arthur was an insulting fraction of market value, barely $80,000, arguing the land was inherently valueless due to its topography. Harrison Vance sat in the front row of that council meeting, a smug smile plastered across his face. The trap was sprung. Arthur had 30 days to vacate, or the county sheriff would remove him physically. The town thought it was over. They thought the old farmer had finally been backed into a corner he couldn't escape. But 2 days before the eviction deadline, Arthur's attorney, a retired, 80-year-old country lawyer named Thomas Higgins, who hadn't stepped into a courtroom in 15 years, filed an emergency injunction. The basis of the injunction wasn't a plea for mercy or an appeal to environmental preservation. It was a quiet, formal demand for a title quietness hearing based on evidence contained within an escrow deposit held by the county court since November of 1978. When the morning of the preliminary hearing arrived, courtroom 3B of the county courthouse was packed to capacity. It wasn't because the public cared about Arthur Vance's fate, it was because Harrison Vance had invited the local press to document what he believed would be a swift, administrative execution of the eminent domain order. The local newspaper had already drafted a headline about Oakhaven's modernized infrastructure expansion. Harrison sat at the front of the gallery, flanked by a team of 3 high-priced corporate attorneys from the state capital. They wore tailored charcoal suits, carried Italian leather briefcases, and exuded the supreme confidence of men who had never lost a municipal property dispute. They looked at Arthur, who sat alone at the defense table, like a legal formality waiting to be cleared away. Arthur looked exactly as he always did, clean, but entirely out of place in a room filled with polished mahogany and brass. His old attorney, Thomas Higgins, arrived carrying nothing but an old leather folder that had begun to peel at the edges. Higgins' hands trembled slightly as he arranged his reading glasses, prompting a collective, suppressed smirk from Harrison's legal team. Judge Evelyn Sterling, a no-nonsense jurist with 25 years on the bench, called the session to order. Harrison's lead counsel immediately took the podium, delivering a seamless, authoritative presentation. He used glossy, high-definition topographical maps to demonstrate that Arthur's Basin was a geographic hazard, prone to flooding, and that the town's use of eminent domain was a textbook application of public safety necessity. The presentation was flawless, relying heavily on modern municipal codes passed by the town council over the last decade. When the corporate lawyer wrapped up his argument, he looked at Judge Sterling and concluded, "Your Honor, the respondent has provided no legal basis, no engineering data, and no valid counterclaim to halt this vital infrastructure project. We ask that the injunction be denied immediately." Judge Sterling peered over her glasses at the defense table. "Mr. Higgins, the floor is yours. I read your filing regarding an escrow deposit from 1978, but the court records from that era are notoriously incomplete due to the old archives fire. What exactly are you introducing today?" Thomas Higgins slowly stood up, leaning heavily on the table before straightening his posture. He didn't look at the high-priced corporate lawyers, he looked directly at Judge Sterling. "Your Honor," Higgins began, his voice surprisingly resonant for a man of his age, "the town of Oakhaven has based its entire seizure on municipal codes and zoning maps established between 1995 and the present. They are operating under the assumption that this land was unencumbered agricultural property when those ordinances were written." Higgins paused, reaching into his peeling folder. "But law, as this court knows, is built on foundations, not additions. In November of 1978, long before Oakhaven became an incorporated town, the county accepted a sovereign conditional trust. That trust was established by Arthur Vance's grandfather, Silas Vance, and verified by the county clerk at the time." Harrison's lead attorney stood up immediately. "Objection, Your Honor. This is an archaic distraction. Any unrecorded historical trusts were voided when the municipality incorporated in 1984 under state statute. It wasn't unrecorded," Higgins shot back, his tone suddenly sharp as steel. "It was placed in judicial escrow, specifically designed to activate only if the county or any future municipality attempted to alter the natural drainage or ownership of the valley basin without the unanimous consent of the Vance bloodline heirs." The courtroom went dead silent. Judge Sterling frowned, looking through her docket notes. "Mr. Higgins, if such an escrow existed, where is the physical record? The court archives from that decade are gone." Higgins turned and pointed to the back of the courtroom, where a uniformed county bailiff was standing next to a heavy, industrial-grade utility cart. Restating his motion, Higgins said, "Pursuant to County Registry Statute 44A, we requested the retrieval of secured box number 78-0912 from the state's Deep Vault Auxiliary Archive in the Capitol. It arrived this morning. It has remained under judicial seal for 48 years. The bailiff wheeled the cart forward. On it sat a heavy, industrial steel lockbox. The green paint was chipped and rusted at the hinges, but the heavy red wax seal across the latch was completely intact, stamped with the official insignia of the 1978 County Court. Harrison Vance leaned forward in his seat, his smug expression flickering for the first time. He whispered frantically to his lead attorney, who simply shook his head, rapidly typing into his tablet. They had run asset checks, title searches, and lien histories, but they had only checked digital databases. They had never checked the physical, deep storage state archives for sealed judicial escrows. Judge Sterling gestured to the bailiff. "Break the seal." The bailiff used a pair of heavy-duty wire cutters to snap the vintage security wire and crack the hardened wax. The sound of the metal latch snapping open echoed through the quiet courtroom like a gunshot. Judge Sterling leaned forward over her bench, watching intently as the bailiff lifted the heavy steel lid of the 1978 box. A faint, musty scent of aged parchment and disintegrating rubber bands drifted across the front row of the gallery. Inside the box lay several thick bundles of documents, tied together with faded red twine, alongside a series of large, linen-backed engineering maps. Thomas Higgins stepped forward, pulling a pair of white cotton archival gloves from his pocket. "Your Honor, with the court's permission, I would like to submit Exhibit A into evidence, the original 1978 sovereign indenture and drainage right-of-way agreement between Silas Vance and the County Board of Commissioners." Harrison's lead attorney was on his feet instantly, his polished composure beginning to crack. "Your Honor, we must object to the introduction of these documents without a prior authenticity review. We have no way of verifying if these papers have been altered or if they comply with modern real estate disclosure laws." The box was retrieved from a climate-controlled, high-security state auxiliary vault, Counselor, Judge Sterling said, her voice dripping with ice. "The wax seal was unbroken until 2 minutes ago, stamped by my predecessor, Judge Marcus Vance, who, if I recall my local history, was your client's own granduncle. The objection is overruled. Mr. Higgins, please proceed." Higgins untied the first bundle, unfolding a crisp, heavy sheet of legal paper bearing an official notary stamp from 48 years ago. He cleared his throat. In 1978, the county was planning its very first major highway expansion, the route that eventually allowed Oakhaven to experience its massive suburban boom. To build that highway, the county desperately needed a right-of-way across the northern edge of the Vance family farm. Silas Vance, Arthur's grandfather, agreed to deed that land to the county for a token price of $1. The gallery murmured. $1 for land that was now worth millions. It sounded insane. But, Higgins continued, raising a finger to command the room, Silas Vance was a visionary. He saw that the surrounding hills would eventually be paved over. He knew that when you replace grass and dirt with concrete, rainwater has nowhere to go. It rushes downhill. And geometrically, all that water was destined to flood this specific low-lying basin, the very land Arthur Vance lives on today. Higgins walked over to the defense table, picking up one of the linen-backed maps and unrolling it across the presentation board. It was a highly detailed, hand-drawn hydrological survey of the county, dated September 1978. Silas Vance knew his farm would become the literal drain bucket for the entire region. So, he inserted a restrictive covenant into the deed transfer. The covenant states that in exchange for the highway right-of-way, the county, and any future municipal entity that succeeds it, is legally bound to maintain the Vance Basin as a private, unencumbered agricultural sanctuary. Harrison's corporate lawyer adjusted his tie, trying to regain his footing. "Your Honor, even if such a covenant exists, modern municipal law allows for the termination of restrictive covenants if the public interest heavily outweighs the private use. The town is offering compensation. This changes nothing." "It changes everything, Counselor," Higgins said calmly, turning the page of the legal document. Because Silas Vance didn't just write a standard covenant. He utilized a rare, ironclad legal mechanism known as a fee simple subject to an executory limitation. It dictates that the moment the county, the town, or any developer attempts to force a change in the zoning, topography, or ownership of Arthur Vance's basin without his explicit, written consent, the entire highway right-of-way granted in 1978 instantly and automatically reverts back to the Vance estate. A heavy, suffocating silence dropped over the courtroom. Harrison Vance's face drained of all color. He stood up slightly from his bench, staring at his lawyers with wide, panicked eyes. To the average person in the gallery, the term executory limitation sounded like legal jargon. But to Harrison's high-priced corporate attorneys, it was a financial death sentence. They knew exactly what it meant. If the town of Oakhaven used eminent domain to seize Arthur's 80-acre basin, the legal ownership of the main 4-lane highway cutting directly through the center of Oakhaven's commercial district would immediately revert to Arthur Vance. The town didn't just risk losing a lawsuit, they were on the verge of accidentally handing the keys to their entire economic infrastructure over to the old farmer they had spent 20 years mocking. The luxury subdivisions, the shopping centers, the country club, all of their traffic flowed across land that would legally become Arthur's private property the second the eminent domain pen touched paper. Judge Sterling stared at the document in front of her, a look of profound astonishment crossing her face. She looked at Harrison's legal team, whose tablets were now completely abandoned. "Mr. Counsel," Judge Sterling said quietly, leaning forward. "Does your client wish to proceed with the motion to enforce eminent domain today? Because based on this 1978 indenture, if I sign that order, Mr. Arthur Vance will have the legal right to erect toll booths on Highway 41 by sunrise tomorrow." The panic in Courtroom 3B was almost palpable. Harrison Vance's lead attorney frantically pulled his client down into his seat, whispering fiercely into his ear while gesturing toward the ancient documents lying on the evidence table. The local journalists in the back row were typing furiously on their laptops, realizing that what was supposed to be a boring municipal hearing had just mutated into the biggest financial scandal in the county's history. Harrison was shaking his head, his face a deep shade of crimson. "There has to be a loophole," he hissed loudly enough for the front row to hear. "We incorporated the town in 1984. A pre-incorporation county agreement can't possibly bind a modern municipal city council." Judge Sterling slammed her gavel down once, the sharp crack cutting through the rising murmurs of the room. "Mr. Vance, if your legal counsel cannot control your outbursts, I will have the bailiff remove you for contempt. This is a court of law, not a boardroom." She turned her gaze back to the defense table, looking at the calm, weathered face of Arthur Vance, who had not moved a single muscle since the hearing began. He sat with his hands resting quietly on the mahogany table, looking less like a man who had just won a multi-million-dollar legal standoff and more like a farmer waiting out a brief summer rainstorm. Harrison's lead attorney stepped back up to the podium, his posture noticeably deflated. His authoritative, booming voice from earlier was entirely gone, replaced by the tentative tone of a lawyer trying to mitigate a catastrophe. "Your Honor," the corporate lawyer began, his hands gripping the edges of the wooden podium. "Given the unexpected complexity of the historical documents introduced by the defense, the municipality requests a 60-day continuance. We require time to independently audit the state archives and consult with the State Department of Transportation regarding the validity of this reversionary clause." 60 days. Thomas Higgins scoffed, standing up without the support of the table this time, his old spine straightening with a sudden surge of energy. "Your Honor, my client has endured 48 months of targeted administrative harassment. He has been fined for the grass on his hills, the tools in his barn, and the mud on his driveway. The town council has spent years trying to bleed him dry through arbitrary code violations so they could force him off his land. They didn't want a storm basin, they wanted to clear the way for Harrison Vance's Phase 4 luxury commercial plaza. They brought this emergency eminent domain motion to this court today demanding an immediate eviction. We are here, we are ready, and we demand a ruling today." The gallery watched in breathless suspense. Judge Sterling looked down at the 1978 indenture, then at the town's legal team. "The request for a continuance is denied," Judge Sterling ruled flatly. The language of the 1978 sovereign indenture is perfectly unambiguous. It is a matter of public record, safely preserved under judicial seal. The town of Oakhaven assumed it could build its modern empire without checking its structural foundations. That was a catastrophic legal error on the part of the Municipal City Planning Commission. She picked up her pen, looking directly at Harrison Vance. "The court denies the town's motion to enforce eminent domain. Furthermore, this court issues a permanent structural injunction protecting the Vance Basin from any future municipal seizure, zoning alteration, or administrative interference under the 1978 covenant." The gavel came down with a definitive thud. But as the gallery began to cheer, Arthur Vance did something he hadn't done throughout the entire decade of his dispute with the town. He stood up. He walked over to the podium, gently tapping his old attorney on the shoulder. Thomas Higgins looked surprised, stepping aside to let the old farmer take the microphone. The courtroom instantly went dead silent again. Everyone, from the journalists to the trembling corporate lawyers, wanted to hear what the quiet outcast of Oakhaven had to say. Arthur adjusted the microphone, his voice deep, gravelly, and carrying the slow, deliberate rhythm of rural life. He didn't look at the judge, and he didn't look at the press. He looked directly at his cousin, Harrison. For 20 years, Harrison, you and the council treated me like a fool because I wouldn't sell, Arthur said quietly. You thought I didn't know what the land was worth. You thought I was just a stubborn old man holding on to a swamp out of spite. Arthur reached into his canvas jacket pocket and pulled out a small, yellowed piece of paper, a carbon copy of a receipt from 1978. My grandfather Silas didn't leave me this land to make me rich, Arthur continued, his voice steady and cold. He left it to me because he knew what happens when greed takes over a valley. He knew that if you pave over everything, the water has to go somewhere. If I had sold this basin to you 20 years ago, your luxury subdivisions would have flooded the very first winter, because you don't care about the engineering, you only care about the quarterly profits. Arthur leaned closer to the microphone. I paid every single one of your corrupt code fines because I wanted a documented paper trail of your malice. Every fine you levied against me is recorded in the county clerk's ledger as a targeted act against an agricultural sanctuary. And now that the court has validated the 1978 trust, those fines constitute a structural breach of the original highway agreement by the city council. Harrison's lead attorney swallowed hard, his face turning an ash-gray color. He realized what Arthur was doing. He wasn't just defending his farm, he was preparing a massive counterstrike. Arthur Vance let his words hang in the heavy air of Courtroom 3B. He let the corporate legal team calculate the catastrophic implications of what he had just revealed. By systematically paying those arbitrary municipal fines under protest, Arthur hadn't been submitting to their authority, he had been collecting ironclad judicial evidence of a targeted, bad-faith breach of a sovereign 1978 contract. Your Honor, Thomas Higgins said, stepping back to the podium with a newfound sharpness in his stride. In light of the court's validation of the 1978 sovereign indenture, we are filing a formal counterpetition for breach of covenant and systemic municipal malice. We are seeking the immediate return of the Northern Highway right-of-way to the Vance estate, along with punitive damages equal to the cumulative total of every illegal administrative fine levied against my client over the past 20 years, adjusted for inflation. Harrison's lead counsel didn't even bother to stand up to object. He simply looked down at his legal pad, his pen resting completely still. He knew the math. If the right-of-way reverted to Arthur, the town of Oakhaven would be forced to pay millions in usage lease fees just to keep their main economic artery open, or face the physical closure of Highway 41. The town's credit rating would drop to junk status overnight, municipal bonds would fail, and the city council would face total financial liquidation. Harrison Vance looked completely broken. The arrogant, pristine developer who had spent decades looking down on his cousin from his air-conditioned boardroom was now staring at a financial abyss. He leaned across the aisle, his voice cracked and desperate. Arthur, please. Let's talk about this outside the courtroom. We're family. We can figure something out. Name your price. Arthur looked at Harrison, his expression entirely unreadable. There was no triumph in the old farmer's eyes, no malice, and no joy. There was only the cold, unyielding clarity of a man who had spent 40 years watching the land change around him. I told you my price 20 years ago, Harrison, Arthur said softly, his voice cutting through the silent room. I told you the land wasn't for sale. But you couldn't accept that a man could want something more than a check. Arthur turned back to Judge Sterling. Your Honor, my grandfather didn't want to destroy this town. He wanted to protect the valley. I have no desire to close the highway or bankrupt the taxpayers who were lied to by their elected officials. But things are going to change in Oakhaven. Arthur laid out his conditions right there in open court, completely bypassing the standard months of bureaucratic negotiation. First, the town council had to immediately repeal every single modern zoning ordinance that allowed corporate development within a 2-mile radius of the basin watershed. Second, the entire 80-acre Vance parcel was to be legally reclassified as a permanent, non-transferable ecological and agricultural trust, funded in perpetuity by the municipal taxes generated by Harrison's commercial properties. Third, Harrison Vance's development firm was required to pay for a state-of-the-art, independent hydrological engineering system to ensure that the stormwater runoff from the luxury subdivisions was properly filtered and managed, entirely at their own expense. If the town council signs that binding agreement by 5 o'clock this afternoon, Arthur concluded, I will waive the right-of-way reversion and allow the highway to remain public property for another 50 years. If they don't, Mr. Higgins will file the seizure order at 5:01. Judge Sterling looked from Arthur to the trembling municipal representatives. I suggest the town council call an emergency closed-door session immediately, she remarked dryly. Because I will be in my chambers waiting to sign whichever document lands on my desk first. By 4:30 p.m. that afternoon, the Oakhaven Town Council had unanimously signed the agreement. It was the fastest legislative action in the county's history. Harrison Vance's firm was forced to absorb massive, multi-million-dollar infrastructure costs to fix the drainage issues they had spent years ignoring, a financial blow that ultimately forced Harrison into early retirement and stripped his firm of its monopoly over the valley. The next morning, the sun rose over Oakhaven just as it had for decades. The commuters drove down Highway 41, completely unaware of how close the pavement beneath their tires had come to belonging to a single citizen. If you drive through the center of Oakhaven today, past the uniform strip malls and the manicured lawns of the luxury master-planned communities, you will eventually reach a sudden, dramatic break in the suburban landscape. Right in the middle of the high-end real estate sits 80 acres of wild, untouched earth. The grass grows tall on the rocky hills, the old timber cabin stands proudly against the tree line, and the ancient 1950s farm equipment rests peacefully inside the open barn. The people of Oakhaven don't whisper or laugh when they drive past the old farm anymore. They don't file code complaints, and they don't deliver administrative citations. Because they finally understand that the quietest man in the valley wasn't a relic of the past standing in the way of progress. He was the only one who truly understood the law, the land, and the true cost of arrogance.